Before you are members of a civil society reference group, and today we have a press statement, and the title of the press statement is Protection of the Civic Space in the Republic of Kenya as envisaged in the 2010 Constitution, which I proceed to read. Introduction. Kenya has been gradually making progress with specifically the civic space since the pre-colonial days. There was a time when this country had no freedom to decide for itself what to do, but our forefathers demanded self-governance, and it came in 1963. We later on realized that our biggest weakness was the Constitution, and we embarked on a process of overhauling the entire Constitution to address the current realities. Of course, when we went to the referendum in 2010, we agreed that the document was 75% okay and more progressive than the pre-colonial constitution. Of course, knowing that with the time we would amend. The entire 2010 constitution, from Article 1 to Article 264, and all the 18 chapters in the constitution reinforce and protect the civic space. The constitution was designed to enhance the best interests of the people. The colonial mindset was to deny us the power to make decisions that concern us. The 2010 Constitution reversed this with self-regulation, self-governance, and best practices from other functional democracies. The civic space, as envisaged in the 2010 Constitution, for example, the Supreme Court was specifically established to resolve gaps in law that were threatening national unity, rule of law, and constitutionalism. It specifically addressed issues surrounding presidential election disputes because the presidency represented and still represents nationhood, state, and governance. This is the highest level of safeguarding people's sovereignty. Separation of powers among the three arms of government guarantees checks and balances, reinforcing the civic space and people's sovereignty. Devolution, as envisaged in Article 174, is a means of self-regulation and self-governance at the grassroots, as envisaged so that there is direct exercise of sovereignty by the people through the established institutions. The Bill of Rights, from Article 19 to 59, emphasizes recognition, protection, and enhancement of the civic space. Public participation in governance both at the national level and the county level, as envisaged in Article 118 and 196, is a constitutional means of protecting the civic space. The PBO Act implementation and the current status. The PBO Act was signed into law in 2013 by the late President Mwai Kibaki, and by default, a bill comes into force 14 days after being passed by Parliament as provided for in Article 116. The PBO Act was operationalized on 14th May 2024, 11 years after being passed by Parliament, a sign that there was no political goodwill to do so for 11 years. We congratulate His Excellency President William Ruto for the political goodwill that led to the commencement of the PBO Act last year. There are provisions in the PBO Act that had specific timelines immediately after commencement of the Act, and CSRG made a deliberate follow-up with the relevant government departments concerning the PBO sector. We met the PBO Federation that had transitioned, led by Mr. Cheboy. We petitioned the PBO Regulatory Authority that had transitioned, formerly the NGO Coordination Board. We petitioned the CS for Interior at the time, now the current Deputy President, Honorable Kithure Kindiki. We petitioned the President seeking transfer of the PBOs from the Interior Ministry to the Department of Planning and Finance, and to fast-track implementation of the PBO Act, but none of the named bodies responded to us. The PBO Regulatory Authority organized a meeting last year at KICC, and we attended. We raised the same concerns we had on the gaps, gray areas in the Act, and offensive clauses that did not conform to the 2010 Constitution. They agreed with us that the PBO Act has gaps, and they will seek the advice of the Attorney General on the same. As concerned citizens of the Republic of Kenya, having exhausted all the channels, we went to court to seek interpretation on the offensive clauses in the PBO Act and direction on the gray areas. The High Court made judgment on the issues raised on 30th April 2025. So the PBO Regulatory Authority is unconstitutional. This is the ruling of the court. It's in office, not in conformity with the Constitution. And we urge the PBO Regulatory Authority to respect the court ruling and halt the ongoing activities until they appeal against the decision of the High Court and get a contrary ruling. As things stand right now, they are breaking the law by acting contrary to the ruling of the court. Emerging issues surrounding the civic space in the country. There has been a delay in the implementation of the PBO Act. The CS for Interior and the PBO Regulatory Authority disregarded timelines in the PBO Act, the spirit of dialogue, consultation, stakeholders' engagement, and public participation. The PBO Regulatory Authority is sabotaging the court process by proceeding to act in office contrary to the High Court ruling. The police have neglected protection of lives and property during demonstration, and this is their core responsibility. There is continued disregard for the rule of law and the constitution by state officers. We have heard of proclamations of shoot to kill or shoot to maim, increasing cases of deaths everywhere every time there are demonstrations. Politicians are hijacking a process that has been issue-based. Now they have made it become a political tool, when originally it was a discussion about the issues affecting our country. Now CSRG has got recommendations. The first one, we are reminding the PBO Regulatory Authority to respect the court ruling. And if the government or the PBO Regulatory Authority has no intention of appealing against the court ruling, then the best thing that should be done is the current CS for Interior, in whose docket there is the implementation of PBO Act, to take it back to the Parliament so that Parliament aligns the Act with the ruling of the court. And then we revert to the timelines that are in the PBO Act to make sure that it is fully implemented. Two, the Kenya police must respect their responsibility and take it seriously. We know their commandate is to maintain law and order and to protect lives and property. We have seen they are not doing that. And the suggestion that they should shoot protesters is not in the Constitution. The Constitution in Article 37 is very clear that the citizens of this country have got a right to picket. Now, when you say they should be shot, either in the arm, in the leg, any form of shooting, it's like you are intimidating them not to, you are telling them not to come on the street, not to protest. And that it will be contrary to the Constitution. So we know in the country we already have people living with a disability. Now, if we shoot people in the arm, we'll be increasing the number of people who are disabled. And if the government has not fully satisfied the needs of those who are already living with disability, if the number increases, what will happen? Okay, so the other thing also, we are reminding the government to compensate all victims of police brutality. Through thorough investigation must be carried out in all cases of police brutality. We are calling on independent commissions to take up their role seriously of ensuring that there is protection of the civic space. The government must respect the voice of the citizens so that whatever issues that are of national concern, they may be taken through the process of public participation, through the institutions established through the devolution process. Especially, we know we have the ward and we have the villages as forms of devolution. If they can be processed through that, I think we'll have a more engaged, a more deliberate way of solving problems that is people involving. We petitioned the office of the president, we petitioned the office of the CS Interior then, now the current deputy president. We petitioned the PBO Regulatory Authority, the one that had transitioned, regarding the gray areas and the issues we thought were not okay in the PBO Act, the gray areas and the gaps we saw in the Act. None of them responded to us. So we had no option. We went to court, and on 30th of April, the court made a ruling that the PBO Regulatory Authority is unconstitutional, is in office illegally. And we're wondering why they are not respecting that. If they have no intention of appealing against the decision of the High Court, they should stop the activities that are going on. They are doing public participation. So we are reminding them to respect the process of the court. And if they have no intention of appealing, take the act back to Parliament so that the Parliament aligns it with the ruling of the court. We are behind schedule because within 1 year, all these processes were supposed to be complete. And 1 year was lapsing on 14th of May this year. Now you see we are past 1 year, and now it's when the PBO Regulatory Authority, in quotes, is doing public participation on regulations. We saw the goodwill from the president, and we are still hopeful that the president will maintain the goodwill in implementing the PBO Act so that we open up space. In fact, from where we sit as CSRG, if they had implemented the PBO Act fully, right now we'll not be having the problems we are having that are surrounding the demonstrations, because we would be having self-regulation forums that will be regulating protests the same way the Matatu circles do. The circles make the Matatu industry to account. Now self-regulations will be the ones that will be answerable whenever there are malfunctions or malpractices during demonstrations. We strongly condemn destruction of property. As we said, we are not partisan. We are telling citizens that demonstrations are not supposed to be accompanied by destruction of property. So those who are destroying property, those are criminals that should be prosecuted. We are also telling those political leaders who are inciting the public to stop. We are also telling the government state officers who are also going against the law by not protecting those during protesters. They must protect protesters and ensure that the constitution is upheld. Tunajua vizuri our constitution, article 131, inapea president the authority ya kuwa a symbol of national unity. So we are reminding the president, sisi kama civil society reference group, we are not partisan. We are not supporting or opposing the government. We are not supporting or opposing the opposition. We are not supporting or opposing the demonstrators. We are only taking the position of the constitution and the law. And what we are insisting is that the constitution recognizes that the president is a symbol of national unity. Meaning, everybody in this country must feel safe under the president. Now, if the president says that they should shoot demonstrators in the arm or in the leg, it means he is intimidating people who want to demonstrate. And that way, we will be disregarding the constitution. And Article 37 is very clear that there is freedom of picketing. So we are reminding the president that please do your responsibility by ensuring that everybody feels safe under you. And this goes by extension even to all other government officers. We saw the Speaker of the National Assembly addressing a public gathering in Rift Valley, and is calling on the citizens to protect the president. You know that is not supposed to happen, because the president is already protected by the constitution. The president cannot be prosecuted while in office. The president is already protected by the army, protected by the police and all the state machinery. Why would the citizens be needed to protect? That is incitement. So we do not want to hear such kind of statements, and we are insisting that there should be no shoot to kill or shoot to maim anyone. The government should do its bit by ensuring that the police protect lives and protect property.
Kwa majina yangu ni Faith Mwangi, Nairobi convener CSRG. Na leo tumekuja hapa tukiwa kama kikundi cha CSRG kusema ya kwamba hatusupport na hatukatai government, hatusupport na hatukatai opposition, but yetu ni kusema ya kwamba lazima watu washikilie constitution na wafuatilie constitution to the letter. Kwa sababu ya kwanza, wakati tulileta constitution 2010, ni kitu iliyokubalika nchi nzima. Ni kitu ilitufungulia hata watu kujiongea na kusema yaliyo ndani mwao ama yale ya wanawafinyilia. Lakini ile kitu tunaona saa hii kwa hii nchi ni ukiongea ama kukosoa serikali unashikwa. Ukiongea ama kudemonstrate unashikwa. Kitu ya kwanza tunasema hatukubaliani na uharibifu wa mali, hatukubaliani na wizi, hiyo tumekataa kabisa. But ni haki ya mwananchi kuongea na kudemonstrate na kutembea kwa barabara wakisema yaliyo ndani mwao, na ni haki wasikizwe. Kwa hivyo tunasema ya kwamba polisi wana kisheria lazima waprotect mali ya watu na waprotect watu wakati wana picket ama wana demonstrate. Kwa hivyo hii mambo ya kusema ya kwamba hatuna haki za kutetea haki zetu kwa hii nchi imeenda to another level. Na tungeomba serikali na tungeomba opposition, hizi mambo mnafanya ama haya mambo mnaongea yarudi chini. maana hii inchi hatutaki kuona ikienda in the way of anarchy. We want the opposition and the government to stop trivializing what the people are crying about. When you see children on the streets crying, placing their issues, let it not be politicized by either the government or the opposition. Let them be listened to, because there is a point that they are trying to put across. It is said by the wise, even a madman has a word that they can give. It is in order for everyone to listen and to hear and to know where the agitation is coming from. For example, when we look at the PBO Act, where we have been very instrumental in following up and seeing that it is implemented to the letter, you find that the PBO Act has not been implemented to the letter. In fact, as my colleague said, we questioned them at KICC. And what the CEO of the PBO regulatory body said is that even them, they are a bit confused on how to implement it. We wait together and learn how to implement it together. Now we find them, they are not giving the way forward. The court has pronounced itself, but the law is not being followed. That begs a question. Is this country having any obedience or having any political goodwill or having any sense of following the constitution or the law? These things are so broad, such that we cannot allow this country to go back the 207 way. We are beyond tribe, we are beyond everything. We are saying in unison that this country should be based on the constitution and the laws that are. And therefore mine is to beg the judiciary. You are the only reason that is left in this country. Let the law be followed to the letter. What I'm seeing is a lot of political bickering, a lot of back and forth of people who have no goodwill of protecting the citizenry that are there. So whether it is the opposition or the government, none of them have the goodwill to implement the law as it is.
My name is Catherine Banda from Civil Society Reference Group, Nairobi County. My main question is, why have a constitution and it's not functional? As Kenyans, we have a very good constitution compared to other countries. But why have it and it's not functional? Secondly, why have it and it favors specific group or specific persons and not all of us as a nation or as a country? That's a question for thought for all of us as Kenyans and also to the government.
My name is Stephen Omondi, and we as Civil Society Reference Group would urge the President to protect, defend, and uphold the Constitution of Kenya's sovereignty. We are perturbed by the statements that come out from the head of state, the MPs, and all those who represent the government at large. Our humble urge and desire is the President to ensure that peace and justice be our shield and defender as a country and to all the citizens. We should take it as a sole responsibility, we the citizens of the Republic of Kenya, to give guidance or to speak our mind on whatever we need. If we see the government and the President coming out largely and boldly, talking about shoot to kill innocent citizens who are exercising their rights that are enshrined within the Constitution, we are getting back to the old dark days, which we should not go back to that regime again. We urge the President to come out, protect and uphold the Constitution of Kenya.
My name is Elizabeth Kamene from Civil Society Reference Group of Kenya. As you have heard all my colleagues mentioning about the Constitution, it is true. If we want to move on good as a country, we need to follow the Constitution. As it is stated that you have a right to peaceful demonstration. And also for the protesters, it is good to follow the Constitution, not to distract people's properties. And to many people who have really engaged with CSRG Kenya, we have shown interest in joining our CSRG Kenya. We have an online membership application form at CSRG, Civil Society Reference Group at Facebook, and at Twitter we have CSRG Kenya. The membership is ongoing, and if you want to join CSRG, kindly engage with us. And we mobilize for accountability, mobilize to defend the Constitution, mobilize for transparency, and luta continua.